Given the controversial history of the Faint Hope regime, the rationale for Bill C-36 is very simple. Allowing convicted murderers a chance, even a faint chance, of getting early parole flies in the face of truth in sentencing. A court and a judge has sentenced a person to life imprisonment with no eligibility of parole for 25 years. But this clause undermines that. As the short title of the bill indicates, Madam Speaker, truth in sentencing means that those who commit the most serious of crimes must do the most serious time. This is what is proposed in C-36, to restore truth in sentencing for murderers and to protect society by keeping potentially violent offenders in prison for longer periods of time. And pleased to note that C-36 fulfills the long-standing commitment of this government to repeal the Faint Hope Clause for future offenders and to tighten up the current application procedure in the interest of the families and the loved ones of previously murdered victims. C-36, if it allowed to proceed to a vote, if this motion is rejected by this House, will bar those who commit murder or high treason from after the legislation comes into force from applying for Faint Hope. In effect, the Faint Hope regime will be repealed for all those who commit murder in the future. It will also toughen the application process for those already sentenced lifers with the right to apply for Faint Hope by setting a higher judicial screening test. From now on, a judge will have to be satisfied that there is a substantial likelihood that a jury will unanimously agree to reduce an applicant's parole and eligibility period. Moving from, quote, reasonable prospect, unquote, to a substantial likelihood of success will likely screen out the most undeserving applications and therefore sparing the victims' families of the individuals that those applicants have been convicted of murdering. There are also longer waiting periods for reapplication in the event of an unsuccessful initial Faint Hope application, a minimum 5 years instead of the current 2-year waiting period for reapplications. Finally, Madam Speaker, Bill C-36 will impose a new 3-month time limit for the offender to apply or reapply under the Faint Hope regime. The 3-month time limit will apply in the following situations. First, it will apply to those offenders who have served at least 15 years of their sentence and have not yet applied. There are many offenders in prison now who have served 15, 16, 17, and more years, but who have not yet applied. These offenders will have to make the application within 3 months of the coming force of this legislation or wait another 5 years. Secondly, it will apply to those offenders who are now serving a sentence but who have not yet reached a 15-year mark. For example, they may have served 4 years or 8 years or 10 years when this bill passes. After the 15-year point exactly in their sentences, all of these murderers will have to bring an application within the window of 3 months. There is also, Madam Speaker, a 5-year waiting period during which an offender may not apply at all if he or she does not apply to a judge within the 3-month new time limit. So to sum up, these new longer limits are explicitly designed to reduce the number of applications that someone may make, and in order to spare the families and loved ones of their victims from having to rehash the details of the crime every time a particular applicant applies for Faint Hope. In closing, and this time I mean in closing, C-36 will eliminate the Faint Hope regime for all future murderers and will ensure that all murderers now in prison have a much tougher time accessing this regime. None of the substantive aspects of C-36 have been amended in any way by the committee. I see no point in the bill going back to committee. We've heard cogent evidence from witness groups, from witness advocates. We've also, of course, heard from adversaries of Bill C-36, including Elizabeth Fry and John Howard and other groups that have appeared before the committee. The reforms of the Faint Hope Clause regime will accomplish worthwhile goals, allowing Canadians to feel more protected in their homes and sparing the victims of the trauma from having the perpetrators of murder of their loved ones apply for Faint Hope. So I encourage all members of this House to vote against the motion to resend this bill back to committee for further deliberation. Canadians want this bill passed, they want the Faint Hope Clause abolished, and they want it done now, Madam Speaker.
Questions et commentaires?
Questions and comments? The Honourable Member from Abitibi, or for Abitibi-Témiscamingue. Thank you, Madam Speaker, rather. I was listening carefully to my colleague, and we both sit on the Justice Committee, Madam Speaker, and obviously, most obviously, I do not share my colleague's opinions. As a criminal lawyer who has argued cases in court, murder cases and parole hearings, I am very surprised that the Conservatives want to attack a provision that allows a person to have a final or a faint hope of release, and I'll come back to that afterwards. Now, I have only one question, and I'm still awaiting the answer. I would like my colleague to tell me, and because he has figures that we don't have, because unfortunately we weren't able to obtain them, and which is the reason why this motion was tabled here in the House, and why we are going to vote in favor of this motion, this amendment. So my question is that given they have statistics that we do not have, I would like to know if one single person who was able to take advantage of this faint hope clause was ever found guilty of another murder when he was on parole following this process that is allowed for under Section 745.6 of the Criminal Code.
Albert.
Well, thank you very much, Madam Speaker, and I'd like to thank the member opposite for his question and for his participation in this debate. He sits in the Justice Committee, and he knows as well as I do what the statistics are. I outlined the number of applications, and I outlined the number of successful applications, and we had witnesses. I don't know if there's a conclusive study regarding the recidivism of applicants, but we know the number of individuals who have either breached the terms of their parole. Those numbers were made available to the committee, and he knows them as well as I do. My question for him, and he may get a second chance to ask a question, so he may be back on his feet, is if this so-called missing information is available to the committee, and if this bill is referred to committee, of what relevance is it going to be? He's already made up his mind. He's voting against C-36.
Commentaire.